Hey, yo. How's it going? This is David with I'm So Offended. And sorry it's taking me a minute to post. But, I appreciate all the likes, shares, and subscribes and, everybody who's new and has been peeping the channel and some of y'all who reached out to me. You know what I mean? Um, So what we're gonna get into is kind of like a series of videos on the IWO. So I already did a video on the IWO, and basically it had to do with the IWO, that their contract offer that I had received, and that I did nothing about. You know, well, actually, first we're gonna start off with this is for educational and entertainment purposes only. I'm not a lawyer and I don't practice law, and this is not legal advice. I'm not liable for the information you get here and how you use it and what you do, and everybody's outcome is different. You know what I mean? So, so here we go. So in the first video in which I had done uh, a video about the income withholding order. It had to do with the IWO that I was sent, and then I pointed out how, it's not a valid order, right? And so the only power it has is the belief in it being a valid order, kind of like getting a parking ticket. If you believe you actually did something wrong in a parking ticket, you know what I mean? Like you harm nobody. So, anyways, the IWO is nothing but just a contract offer and a scare tactic that nobody has to do. Nobody has to, your employer doesn't have to agree to it. The way that I got out of it from the first video that I mentioned is that I had a cool employer at the time, and I told her, um, you know, don't do anything. All they're going to do is send letters, and they're not going to do anything. They're not going to come after you. And of course, she was scared, but she believed what I was saying. And sure enough, all they did was send letters, and the employer didn't do anything. They didn't do anything. Nothing happened. So the IWO never happened with me. Now, that's not likely that it would happen, but maybe some of you guys have a cool employer in which you could just tell them like, yo, this isn't a court order. It's not real. Um, and then they either choose to do it or they don't, or whatever, but obviously, I mean, they're basically just becoming a third party debt collector for the agency. And when did they become a third party debt collector, right? When did they advocate for the state to collect debts from you? Not to mention they can't do it without consent. So I want to tell you about something that a couple of the guys that I've spoken to have done. I know that two of them have prevailed, and I can't seem to find the other guy's email, but I do have this one here. So, I had to remove his things, so, for his information and whatnot, because I respect y'all's information. But let me go ahead and show you. So this is what this guy did about his income withholding order. So as you can see here, he emailed me, and there's a series of questions that I ask. And so in this series of questions that I ask, I blurred out some of the stuff that I needed to do out of respect for him. But let's look at the red part. Okay, so in the questions that I asked if there's an income withholding order, and if it's been filed, or if they're currently getting an income withholding order. So check out what this guy responded and told me. He said an IWO, look at number 6, was issued in mid-March 2022 after 2 cease and desist notices and some back and forth in the emails. The company I work for has stopped wage garnishment as of June 24, 2022. And it says, mid-March, they created the IWO, saying it to the employer, and I told the hearing officer who called my phone for a teleconference that I didn't consent, and I reserve my rights and to stop threatening me. Okay. Now, number 6 is the more important one between those. he told the company, cease and desist, right? So, and check it out. And I asked him about that. I'm like, okay, all right, what did you put together? And so this is what he put together. Let me see. Let me get the right window there. I thought I had it there. There it is. All right. So we sent them to the wage garnishment, sent them a letter, and, you know, to the county, whatever, from himself in white to the wage garnishment. I guess whoever's doing it, that's his payroll, regarding, you know, what the case is about. Notice of fault and opportunity to cure. All right. So we have March 31st, automatic data processing received a notice to cease and desist withholding of income with the form of the undersigned, employee number. Documents submitted to ADP regarding this notice were notarized and sent by third party via certified mail with return receipts. I have attached the return receipts of this letter. Consider this ADP's second notice to cease and desist all income withholding from the employee's wages. This is ADP's Inc.'s opportunity to cure and return all funds willfully misappropriated back to the employee. With this notice, you have 15 calendar days to comply with the requested cease and desist and return all funds willfully misappropriated or provide a lawful rebuttal. If you choose to ignore the second attempt to remedy this, notice will be introduced as evidence in a court of competent jurisdiction to prove illegal actions being undertaken by ADP. And then he signed it, and he got his notary right there. I like that he attached, you know, the proof by certified mail of the other two notices. I would also put a certified notice on here, you know, just because you don't want to leave anything to chance, right? You don't want to leave anything to chance, you know. But nonetheless, this is what he did and what worked out for him. All right. So, as we saw in this here, it says, after 2 cease and desist notices and some back and forth emails, they have stopped the wage garnishment, okay? And then he sent that cease and desist letter. And check it out. There you go. I asked him to show me. I'm like, did that happen? He's all like, yeah. I'm like, okay, show me. And there it is. Documentation received. To stop garnishment. This is to inform the ADP has received release documentation from your child support order. We will process this within 48 hours, and deduction should generally stop within 1 to 2 pay periods, depending on your pay frequency. So, are you contacting your employer? Are you giving them a cease and desist notice? Sending it certified mail, sending a second notice, a third notice, and you know what? File a lawsuit. File a lawsuit. Don't be afraid to file lawsuits. All right? Check this out, because you have protections. All right, here's what we're going to get into. All right, so these are your protections here. All right, so first and foremost, it's not a court order. Because why? A court order needs 28 U.S. Code 1691 seal and test of process. All writs and processes issuing from a court of the United States shall be under the seal of the court and signed by a clerk thereof. Look at your IWO and tell me if you have these things. Because this is what is required of a valid court order. All right? Not only that, I should have brought this up before I went into this one, but check this out. This was what another guy told them, right? Another guy I spoke to told his employer that just send them back, put return to sender, don't even open them. And he said, look, if something happens to y'all, I will pay the fine. I will pay the fine. Let me show you what I'm talking about. Let me get this one for you. Okay. Here we are. Employer penalty for child support. This is 42 USC 653AA, the establishment. We're going to keep going down, right? This is the law requiring it, having to do with the IWO. Let's go down. Let's go down. Here we go. Civil money penalties for non-compliant employers. Tell them, look, when did you guys become a third-party debt collector? All right, because if I file a lawsuit against you for taking my property, my wages, the fruits of my labor, are they going to protect you, your employer? Is the agency going to protect the employer and retain attorneys for them? No, they're not going to. Ask them this question and tell them, look, I don't want it to go get that far. I want us to be cool. I like working here, whatever. You guys like me working here? Check it out. Look at what it says. For civil money penalties on non-compliant employers, the state shall have the option to set a state civil money penalty which shall not exceed $25 per failure to meet the requirement of this section with respect to a newly hired employee, or $500 if, under state law, the failure is the result of a conspiracy between the employer and the employee to not supply the required report or to supply a false or incomplete report. So make an agreement with them. Be like, hey, how about you guys not report this? If they come after you, I'll pay the $25 fee. You want me to write this down for you? Make an agreement with your employer. Say, hey, if they come after you, like they allege they will, but they won't, I'll pay the fee. I'll pay the $25. And you know what? I'll pay the $500. I'll pay the $500 as well. That's what the law says. It's right there. So ask them to do that. First and foremost, there has to be a series of questions if you want to put this together for them. You want to send a cease and desist? Well, first and foremost, you want to settle things with them amicably. Like, hey, come on, this isn't a valid court order. I do not consent. And let me show you. Look, they're not going to do anything. $25 fine, $500 fine. I'll pay them. I'll pay it. But don't do this. Okay, first of all, I don't consent, and this is not a valid court order, and then you could send your cease and desist. You cease and desist, and then you start putting these laws in there. Well, you could meet with them about the penalty, but in your cease and desist, you don't want to put the law of the fine in there, because you're basically telling them, not to follow it on purpose and to take these fines. You want to meet with them in person and tell them, look, these fines, it's silly, I'll pay them. But if they don't want to listen, then you send your cease and desist and you start showing them, one, this is not a court order. Two, as far as the withholding order, let's look at 45 CFR 32.6. And these are the rules they need to follow, okay? The Secretary, which is the Secretary of Health and Human Services, determines justifies cancellation of a withholding order shall send by first-class mail letter to employer the garnishment order, and within 30 days after debtor fails to make a timely request for a hearing, within 15 days after the mailing notice under this part. Timely request for a hearing must be made by a debtor within 30 days after final decision made by Secretary to proceed with garnishment. There's rules they need to follow. All right, and they're not following all of these due process rules. 45 CFR. This one, just so we can see, is restriction on garnishment in 15 U.S. Code 1673, restriction on garnishment. Okay, we're going to come down to oh wait, which one did I miss here? 32.7. Okay, that one. Okay. Okay, so here we are at restriction on garnishment. See. Oh, I just had it pulled up. Give me 1 second. Oh, okay. Oh, the restriction here has to do with hold on real quick. 15 USC 1673. Oh, it was B. My bad. Yeah, any order, the support of any person issued by a court of competent jurisdiction. So these are the restrictions on garnishment. So the exception is that it must be afford substantial due process, which is subject to judicial review. Yeah, it almost seemed like I spent too much on basically something that said that they needed to follow the rules. Duh. Okay. So E on this one. Sorry about that. Okay. These are your protections. All right. Let's make sure you get this one down. 31 USC 370D, garnishment. Okay. And we're going to come down to E. An employer may not discharge from employment, refuse to employ, or take disciplinary action against an individual subject to wage withholding in accordance with this section by reason of the fact that the individual's wages have been subject to garnishment under this section, and such individual may sue in state or federal court of competent jurisdiction any employer who takes such action. The court shall award attorney's fees to a prevailing employee and, in its discretion, may order reinstatement of the individual, award punitive damages and back pay to the employee, or order or such other remedy as reasonably necessary. This is huge. Okay, so this specifically states about garnishment, that they may not discharge you. They can't fire you or refuse to employ you or take disciplinary action against you if you file a lawsuit against them. This is one that you want to show them as well. And not only can you file a lawsuit, and not only may the employer not fire you or refuse to employ you or take disciplinary action against you, but the agency and the state is not going to protect them from garnishing you. Plus, the court shall award attorney's fees to a prevailing employee and order reinstatement, punitive damages, and back pay. All right. So I'm sorry about that long pause there because I lost myself in what I had in this thing. I just kind of like freestyle this as I go, and I try to have my case laws and everything ready. Maybe I could be a little more better organized for y'all, at least. I mean, I'm organized when it comes to all my paperwork and everything, but I just put this video together last minute, and I'm making this a 3-part series because the first IWO video I did was the one regarding my IWO and how basically it just didn't happen. So that's one way to get out of it if you talk to your employer. And number 2 is you send your cease and desist letters. You certified mail. Make sure you put the number down of the certified mail. Make sure that they got it. First and foremost, you want to talk to them about it because that's what I did with back when I was employed. Talked to the employer about it and said, hey, they're not going to do anything. They're just going to send letters. They didn't do anything. Other alternative methods is telling them about the IWO, start showing them your rights, and send them a cease and desist letter. So we're going to do the part 3 at another time because there's more case law and things. But you can go ahead and pause the video earlier so you can try and write out that same cease and desist letter. I think somebody told me that they used another guy I spoke to said he used the cease and desist letter that was in Rick W's paperwork. They just kind of like changed it up. A lot of guys that I talk to have Rick W's paperwork. The beef of it is pretty good, but some things need to be changed around and all that. And just be careful when you file things like that, make sure it relates to you and all that. Things just need to be changed around. His paperwork isn't ready as is. Okay. So anyways, these are the codes. What was the other one? Oh yeah. The Acts protections. Yeah, this came from actually Credit Consumer Protection Act of 1673. So that's what that was on the restriction on garnishment. Because basically the employee can object to the child support income withholding order, which is basically an individual garnishment of wages. So I'll leave you guys with that for right now, and we'll get into the next one. When I put that together. But review the income withholding videos. Review the first one I did, the income withholding order. Is it valid? No. And then this one here, child support income withholding order, part 2, and then I'm going to make a part 3. Share this with anybody who has an income withholding order. Tell them that they can get out of it. All right. I have proof. I got out of it myself. A couple of guys that I've spoken to have gotten out of it. You can get out of it too. All right. And hit me up on my email if you have questions and whatever. Please support me. This sounds like I'm begging. I'm not begging. I'm doing just fine. But I'm just saying this takes time, and I'm on the phone with a bunch of y'all, and You know what I mean? If you appreciate what I do, man, just, if you $5, if you could give any, donate anything, so that way I can keep doing this, and the algorithm, it gets out, much more, and gets spread around, because there's guys that's been telling me that they've been specifically like looking for me, and and the videos, and like they haven't been able to find certain, like it just doesn't pull up properly or something. So I know that I'm being watched. All right. So, all right. You could see the email in the about section of the video, and yeah,